This short video is to help guide you through the potential legal issues of lecture capture or any other recording. Please note, the information on this video is not legal advice, but best practice guidelines. If you're not sure about the copyright of any material, do not post it online. You should email copyright@ed.ac.uk, who will be able to advise you on the use of any suspect material. In this short video, we'll be looking at copyright, slander, students' legal rights, and the legal rights of you, the lecturer. Let's start with copyright. When lecturing, you may have produced all of the materials yourself. In this case, great. There is not much to worry about. However, it is likely that some of the material are from other sources that you have used within your lecture. This could include films, music, book extracts, journal articles, or photographs. Use of this material within your lecture is covered by the UK Copyright Designs and Patent Act of 1988. However, as soon as the lecture is recorded, this falls outside the remit of use of the material for educational purposes, and it is likely that your material would be infringing copyright. There are several ways of avoiding copyright infringement. You can pause the recording when showing copyrighted materials. You can edit the recording before it goes live. You can provide links inserted into your recording so students can browse the material themselves. You could look for non-copyrighted alternatives by using open educational resources or Creative Commons sources. You could just record the audio, although much of the impact of your lecture is likely to be lost. Or you may decide that your lecture is not worth recording, as much of the material is likely to be under copyright. Let's look at some typical types of copyrighted material. We have extracts from books and journals, diagrams or charts, photos, poems, musical scores and other creative works, maps, including online maps, audio, video, or even websites. It is not to say you cannot use these, but you must check the terms and conditions. As I mentioned, most offline sources such as books, DVDs and journals will not allow copying of their material. However, it is always worth checking their terms and conditions if you would like to use them. Even if it says you cannot use them in the first instance, you may be able to get permission directly from the publisher of the material. You should include details of how many people will be viewing the source, and also assure them that you'll only be using it for educational purposes. The publisher may grant you permission, however, they can also ask for a fee for this. Online sources will also have terms and conditions, although often they will be less restrictive than offline sources. You should check websites for any terms and conditions on the copying of their material. Here we are going to look at Google Maps as an example. Here is what they say about using the screenshot in an online movie. If you're embedding a video or taking still screenshots of Google Earth or maps, you may only do so with full and complete attribution to Google and their data providers, as explained in the permissions guidelines. No explicit permission is required. As you can see, I have attributed the map to them as required in their attributions guidelines. Let's talk a little about Creative Commons copyrights. Creative Commons materials can be very useful, as they have far fewer restrictions on them with regards to copyright. In this slide, you can see the various different flavours of Creative Commons licensing. All of them allow the distribution of works with various caveats. Often you just have to give credit to the author or owner of the material, although you should check the specifics attached to the resource. Many users on Flickr have signed up to using Creative Commons licenses, so that is a good place to look if you need images. Again, There are also links on the lecture capture resource page on the wiki. Slander or libel. This is when you say something damaging to a person or company that cannot be proved. The best thing to do is to avoid this. However, if you do find it has crept into your recording, you should take the recording down and edit out the offending section. Other things to look out for are talking about ethical issues, or perhaps you have some commercially sensitive material that should not appear in a recording. We're now going to talk about students' legal rights. If you're recording a lecture, you should always tell your students. The easiest way to do this, and remember to do this, is to have a slide at the beginning of your PowerPoint. There will be one available on the wiki in the section about lecture capture. Students' performance rights. If a student makes a significant contribution to a lecture, for example, expresses an opinion or something, or perhaps does their own presentation, then you will need their written permission to use them in your recording. There's a form in the lecture capture resource page which covers this. However, if a student asks a question in the lecture, you do not need their permission. But for good practice, you should repeat their question so they can be understood on the recording. Last but not least, the lecturer's legal rights. For the university to be able to publish recordings that they have made of your lectures, you must sign an agreement which waives your rights and assigns them to the university. This means that the university then owns your lectures. However, the agreement also says that you can withdraw your recordings at any time, for any reason. So in effect, you still control your recorded lectures. Again, this agreement can be found on the wiki along with a whole host of other useful information and links. Thanks for watching.